Welcome back to our series about decision-making options in Wisconsin, presented by Davis & Pladel Law Firm. In this episode, we will be providing a walkthrough guide to supported decision-making agreements. Supported decision-making agreements were approved by the Wisconsin State Legislature in spring 2018 after significant lobbying from disability advocacy groups in Wisconsin. The law now is in effect in Chapter 52 of the Wisconsin statutes. The law states that supported decision-making agreements can be used for any person with a, quote, functional impairment or any condition that limits at least one major life activity, such as self-care, independent living, communication, or learning. There are several decisions that fall under the umbrella of supported decision-making agreements. The supporter can help the young adult decide where they want to live and work, which services or care they would like to receive, how to manage their finances, and how to apply for public benefits such as supplemental security income and Medicaid. The creator of the agreement can specify which decisions the supporter can help with, and the supporter does not have authority over the young adult unless expressly given. In supported decision-making agreements, the supporter can be anyone as long as they have no abuse charges, neglect charges, or criminal investigations against them. However, in most cases, the supporter is a trusted adult in the young adult's life, such as a parent, relative, close friend, or caregiver. Any mandated reporter, such as a physician, social worker, or school teacher, is still required to report suspicious activity by the supporter, such as abuse. So what is the supporter able to assist the person with? The supporter can gather information such as medical or financial records that are necessary to make life decisions for the person. The supporter can help the person understand information by breaking it down in a simpler or easier way, as well as explaining the consequences, responsibilities, and alternatives pertaining to the life decision. Finally, the supporter can assist with communicating the person's decision to other people, such as physicians and educators. However, the supporter can only have access to information relevant to the decisions authorized in the agreement. On the other hand, the supporter is not allowed to make decisions on behalf of or without the person. Rather, this more clearly fits a powers of attorney or guardianship situation. The supporter also cannot sign legal documents or legally bind the individual in any shape or form. In the context of guardianship, the supported decision-making agreement cannot be used as evidence of incompetency of the person. It's also important to note that the agreement still allows and encourages the person to access information and make independent decisions they feel comfortable doing without the supporter. When the supported decision-making agreement is created, the creator can specify an end date on the agreement. For example, if they are moving to a new state and no longer have the supporter near them. Moreover, the person can revoke the agreement at any time by either destroying it, executing a written, signed, and dated revocation, or verbally revoking the agreement in front of two witnesses. The supporter themselves may also remove themselves from the agreement and give notice to the person they're supporting. Automatic termination of the agreement occurs if the County Health and Human Services Department substantiates a claim of abuse or neglect by the supporter, if a criminal conviction for an abuse or neglect is placed against the supporter, or if there is an individual at risk injunction granted against the supporter. Based on the information provided, are you interested in pursuing a supported decision-making agreement? Check out the resources in the caption of this video for more information, which include guides from the National Center for Supported Decision-Making, the ARC of Wisconsin, the Wisconsin Board for People with Developmental Disabilities, and the Marquette Volunteer Legal Clinic. It's important to know that the creation of the agreement must be voluntary and known by both the supporter and the person being supported. The agreement must also be signed alongside two witnesses or notarized by a certified notary. However, it's important to note that the supported decision-making process is often lengthy and complex, so it's helpful to have an attorney on your side. If you're interested in a legal consultation about supported decision-making, contact Davis & Pladel by emailing us or visiting our website today.